your question, and I will now hand over to our speaker, Hugh Cumber.
Hi, good afternoon, everybody. Welcome to this webinar on a short lunchtime webinar on issues around the disposal of the deceased's body. Now, this is a huge topic in its own right. So before I really get going, I'm going to address a few topics that this webinar is not about. It's not about issues around organ donation under the Human Tissue Act 2004, although I have noted in my research for this talk that Williams, Mortimer and Sunnox has an interesting thought that you might be able to impose a condition precedent on a gift under your will to ensure that your wishes around your body and organ donation are respected. So that's an interesting thought there, but not one I'm going to be dwelling on. We're also not talking about ecclesiastical faculties or ecclesiastical law generally. Now, there is a huge body of law in this area because you can get faculties from the ecclesiastical courts either for a particular kind of burial, like in the case of Re St. Peter's, where a member of the church wanted to have his ashes interred inside the church, but that was refused because it would have created a bad precedent and everybody would have wanted their ashes there. Or cases of exhumation. The case of Re Durrington Cemetery is a case where the family of a member of the Jewish faith was able to obtain the exhumation from consecrated ground of the deceased and the reburial in unconsecrated ground. And there's a similar case where such an exhumation and reinterment was permitted in the case of a humanist whose wife didn't want him to be buried in consecrated ground. And there's also cases of judicial review, most memorably the Richard III case, the Plantagenet Alliance versus the Secretary of State for Justice, which, as you may recall, involved the remains of Richard III, which were discovered under a car park, and there was a bit of a debate as to where they ought to go. Now, what I'm going to be talking about instead is rather closer to home for me. It's about issues of estate administration. Now, the general rule, as people probably know in relation to estate administration, is that there's no right of ownership in a dead body, but there is a duty at common law to arrange for its proper disposal. Now, the quotation I've given there is from Buchanan and Milton, which is one of the cases I'm going to talk about today, but it's a much longer and better and well-established principle. Now, going on from that general rule, I should say at the outset that this is a rather dubious rule. Its origins are very hard to determine. Some trace it back to a case called Haynes case, which was about the theft of a funeral shroud. But that case only establishes that dead people can't own property. And there's also Dr. Handyside's case, a later case where the doctor who had delivered conjoined twins held onto them and preserved them as a specimen, and the father of the conjoined twins brought an action in detinue to try and recover them, but that was unsuccessful, and so that's sometimes given as authority for the no property rule. I see someone has asked a question already. They've asked whether we'll get a copy of those slides, and if you're able to if you contact Chambers afterwards, I'm sure we can provide a copy of the slides or by way of a PDF or a handout, whichever's most helpful. But continuing with the general rule about the scope of this general rule that there's no property in a body, the scope of it's been doubted in the case of Dobson and the North Tyneside Health Authority. That was a case where, as part of a post-mortem, the brain of the deceased had been preserved in paraffin. And the family of the deceased wanted to recover that brain because they wanted to use the brain as part of the evidence in support of a claim in clinical negligence. And as part of in deciding that case, the court observed that the general rule that had been established since the case of Williams and Williams, that there's no property in a human body, might have an exception where that body has been transformed through the operation of human skill. And so I guess it's an example of where human remains may have been made more property-like. For example, in the case of a mummy that's owned by an artistic collection. But I think that's a very limited exception. And to be fair, the comments in Dobson were only obiter. and it's not entirely clear whether this is even part of the law in this area. So what follows from the general rule? The first and most important rule is that a person cannot control the disposition of their own body. They can make requests, they can appoint people as personal representatives they hope will carry out those requests, and I suppose, as I mentioned earlier, they can leave condition precedents in their will requiring those requests to be complied with. But beyond that, they can't have absolute control. So the duty to dispose of the body and the decisions as to how the body is disposed of falls on the personal representatives of the deceased. And it follows from that that even though there isn't any property in a body, if we accept the general rule, an executor is entitled to seek an injunction for possession for the purpose of disposing, even without a grant. Now, the same isn't true for an administrator. As in other areas, the administrator can't act before a grant in court, and they need to get a grant before they can get an injunction. And under present circumstances, I think everyone can appreciate how difficult that might be in circumstances where obtaining a grant urgently is extremely difficult and is reliant on the court processes. So that creates a rather invidious position for administrators. But the case that I'm going to talk about today might give some limited leeway for people who find themselves in that position in the case of intestacy. Now, what are the consequences of that general rule that I've set out there? What follows from the difficulty that we have that it is for the personal representatives and rather than anyone else to decide what happens with the body? The first and most important for the purposes of today's talk is the dispute is often about who should administer the estate. So many of the cases in this area involve section 116 of the Senior Courts Act 1981. The other corollary of this is the disputes often kick off with an application for an injunction. For example, somebody might be trying to obtain possession of the body to dispose of it in a particular way. Someone might be trying to prevent someone from interfering with the body in its proper disposal. Or somebody might be trying to prevent the disposal of the body by the personal representatives or by somebody else in possession of it in order to allow this issue to be properly determined. And it's interesting in this area, as a sort of trust and estate lawyer, that many of these cases are dealt with like trust disputes. And the cases I've cited there are Hartshorn and Gardner, and the earlier case it relies on, which is Fessy and Whitmore. And in those cases, the court took on itself the decision of how to dispose of the body in situations where the people who were entitled to make that decision couldn't agree. And it's clear from the more recent authorities, including the Oldham case, which was the Ian Brady case I'm going to be talking about in a short while, and from the case of In re K, disposal of body, court's power to authorise, that the court does have power to give directions in this regard. Either it has that power under its general jurisdiction to control the administration of trusts and estates, or it has that power under its inherent jurisdiction. And in re K, that was a case where sadly a child had died and the child's parents were not willing to dispose of the body, and the local authority applied for an order under the court's inherent jurisdiction to allow the body to be disposed of, and the court made that order. And in so making that order, it decided that it was part of the court's inherent jurisdiction to make decisions of that nature. So the cases I'm going to be talking about today are mostly under section 116 of the Senior Court Act. And for that reason, I'll turn to that very briefly. It's probably familiar to everybody here. That section gives the court power if by any reason of special circumstances, it appears to the High Court to be necessary or expedient to appoint as administrator some person other than the person who, but for this section, would in accordance with the probate rules have been entitled to the grant. The court may in its discretion appoint as administrator such person as it thinks expedient. So all of these cases are about whether it's necessary or expedient on the particular facts of the case to appoint somebody other than the people entitled to a grant of administration, or in the case of one of these cases, to the executor, to dispose of the body. And so the first case I want to talk about, a case from 1999, is the case of Buchanan and Milton. This is in many ways a very sad case. The deceased was one of the stolen children of Aboriginal origin who had been forcibly taken away from their parents and integrated into white society, which was a national disgrace for Australia and also indeed for the United Kingdom. Now, during his life, the deceased in that case had found his birth family, and he'd found it to be a very disturbing experience. He then died in the road traffic accident and intestate and survived by his infant daughter. So it followed from that the person primarily entitled to a grant was the infant, but in practical terms, it was the infant's mother. And the intention that was formed was to cremate the deceased. Now, having been informed of the death and of the intention to cremate, his birth family objected on the basis that the Aboriginal belief system was strongly opposed to cremation. And they applied for a grant under Section 116 of the Senior Courts Act to effectively prevent the minor, but the minor's mother from obtaining a grant and going through with her plan to cremate the deceased, and instead intending to have the body returned to Australia so it could be buried among the Aboriginal people. Now, that application was unsuccessful, and it was a decision of Mrs. Justice Hale, as she then was, and I think it's fair to say from reading the decision that she found it to be a very difficult and indeed challenging decision for her to reach. The views of the birth mother were extremely strongly and sincerely held, and she thought that the birth mother, that is, thought that the consequences of cremation, as far as her son was concerned, were very serious. But however, this was just one factor. Against that, the court weighed the views of his English adoptive family, and also the views that his infant daughter might have of the arrangements that had occurred when she reached adulthood. And as part of the balancing exercise, and she very explicitly characterised the exercise he carried out as a balancing exercise, Lady Justice Hale noted that the deceased hadn't embraced his Aboriginal background. It wasn't something he had taken on once he discovered it. And one factor, among others, was that he had continued to use the name that he'd been given at the age of 2 by his adoptive family. So this is a case which demonstrates the way that the principle is applied. The court was in that case willing to accept that there might be special circumstances given the remarkable context in which the case had arisen, but wasn't satisfied that those circumstances made it necessary or expedient to displace the daughter as the person entitled to the grant. Now, this case has some really interesting parallels with the case I'm going to talk about at the end of today's talk, Ganoon and Joshi. But turning from Buchanan and Milton, the next case I want to talk about is the case of Re J.S., a decision from 2017. Now, one of the interesting things about this area of law is, although it's the sort of sub area of state administration, it sometimes can establish some principles of law that have much wider importance for the administration of a state. And this is one such case. The facts, again, are very difficult and sad. There was a terminally ill teenager, a 14-year-old girl referred to in the decision as Jay. And Jay wanted to be cryogenically frozen in the hope that a cure for her disease might be possible in the future. And of course, as a child, she couldn't make a valid will appointing somebody as executor who was willing to carry out that wish. In fact, the people who on her death would be entitled to a grant were her divorced parents. Her mother supported her desire to be appointed, her desire to be cryogenically frozen, whereas her father was opposed to it. Broadly speaking, there was at least fair to say that there was a serious dispute as to what ought to happen. And of course, the parents, under the non-contentious probate rules, would have been equally entitled to a grant of administration in the event of her death intestate. So the court was faced with this very difficult situation, not least because in the case of cryogenic freezing, action needs to be taken very quickly after death if there's any hope at all for it to be effective. And the court found that it had power to make a prospective order under Section 116 of the Senior Courts Act before somebody had died, appointing somebody else to, in this case, the mother, to be administrator. So as you know, under the Senior Courts Act, you can select among the people who are entitled. So you appoint one of them rather than all of them to be the administrator. And the court, interestingly, drew a direct analogy with the trust context and public trustee and Cooper applications, where the court is asked prospectively to bless a particular course of action. It isn't making the decision for the would-be administrator. It is saying that if the would-be administrator took the step in question, they'd be acting properly. And the court was satisfied that the family breakdown combined with the child's special wishes were enough to constitute special circumstances and made the order necessary and expedient, and it also granted an injunction to prevent the father from interfering. So it's a really interesting case, establishing as it does that you can have a prospective Section 116 order in the case of someone who's intestate. And it shows the, I think it's fair to say, creative way that the court will approach these very difficult and diverse situations that it faces on the facts of individual cases. The difficulty that was faced by the court in the next case is of a very different nature. This was the Ian Brady case. I don't need to introduce Mr. Brady. He had died and his executor had wholly failed to dispose of his body. Part of the difficulty that the executor faced was that there was a huge amount of media attention about what was going to happen to Brady's body. There was a report in The Sun recording that he desired to have his ashes scattered in Glasgow. There was also reports that he wanted to have his ashes scattered at the site of one of his notorious murders, and one can understand the public outcry that followed from this kind of press reporting. And the court was rather critical of the executor in this case. He had acted extremely secretively about what his intentions were in relation to the body. During the hearing, he wasn't willing to tell the other parties to the application what his intentions were, and was only willing to tell the court in private, an invitation the court did not take up, perhaps for obvious reasons. And so against this incredibly difficult background, the local authority claimant, Oldham Metropolitan Borough Council, sought an application under Section 116 of the Senior Courts Act, limited to disposing of the body, permitting it to dispose of the body because the executor had failed to do so. And the court was willing to grant that order. But before I turn to the court's analysis, I want to pause briefly on what Mr. Brady's funeral wishes were. He wanted to have his body burnt to a piece of music described as a witch's Sabbath, and the description of this piece of music from the judgment is set out there on the slide. It's a rather, disquieting decision in the circumstances, and the court was very willing to accept that it would be in very poor taste, to say the least, for this wish to be carried out. So the court, referring back to the earlier cases I've already referred to, found it had inherent jurisdiction to direct the disposal of the body, and that the executor was not justified in being so secretive. The court went so far as to say it would be dangerous and inappropriate if he was allowed to carry out the disposal. And this is a case, and the reason I put the case up, apart from its factual interest, is it's a case which shows that the court was willing to micromanage the process of disposing the bodies on the unusual facts of the case. The direction it gave was that the body was to be cremated and scattered at sea. And the court went so far as to say that it would go so far as to direct whether music can be played during the cremation. And in light of the distasteful nature of Mr. Brady's request and the lack of any other stated funeral wishes, the court directed the cremation was to take place out of hours and without any music or other ceremony. So that shows how willing the court is in an appropriate case to roll up its sleeves and get involved in the process. And so that brings me on to the final case, the recent case of Ganaun and Joshi, the case which prompted me to prepare this talk. This was a case, a decision of the High Court in relation to a deceased who had died on the 15th of September 2020. He'd been born in Algeria but lived in England for the last 15 years of his life. He was a practicing Muslim, and I just pause there to note that being buried without delay is especially important in the Muslim tradition, as it is in, I believe, the Jewish tradition as well. And that's a fact, that's a detail that came to have some importance in what happened in this case. Now, there were some interesting details in the background of all of this. One was that the parties couldn't agree what the deceased's name was. Another was that the parties couldn't agree how old the deceased was. There was the suggestion by the deceased's mother that the age that was recorded, the age that was recorded on English records was completely wrong, and that he'd actually been born several years earlier than was suggested on those records. Although it's fair to say that nothing ultimately turned on those details. So what was sought there was a solution to the dispute which had arisen between the claimant, who is the deceased's mother and wanted the body buried in Algeria, and the first respondent, who was the deceased's spouse, who wanted the body buried in the UK. The claim originally came about as a claim for an injunction to stop the spouse from disposing of the body. Now, that injunction application came too late, because on the same day the injunction application was issued, the wife had gone ahead and buried the body, acting on the advice of her imam. Now, the body having already been buried as a fait accompli by the spouse, the mother now wanted an exhumation order and to continue her wishes to repatriate the body to Algeria. Now, such an order can be made in an appropriate case, and I referred to a couple of cases on exhumation earlier, but for these purposes, we're talking about the Section 116 aspect, because that was what the decision was about. Now, in addition to seeking an order under Section 116, the spouse also sought a declaration that the deceased hadn't been buried decently. And I think the basis on which she sought this declaration was that part of the duty of an executor or administrator is to ensure that the body is buried properly. And so I think what the wife, was getting at here was that she was trying to demonstrate that what had been done by the spouse did not amount to a proper burial. And I think she hoped that this would support her in her application for exhumation, in the hope that demonstrating that he hadn't received a proper or decent burial would strengthen her case for exhumation. I'll look at the declaration first, because it gives rise to some interesting comment on the law in this area. The court was not willing to grant the declaration sought. The court wasn't satisfied that this was part of any established legal test. All it was satisfied was that it was a factor in deciding who should be the person under Section 116 who should dispose of the body. And it referred back to an earlier decision where the most important consideration in answering that question was that the body be disposed of with all proper respect and decency, and if possible, without further delay. Now, that's interesting, because as I said on the very outset, since Buchanan and Milton, it's been clear that disposing of the body properly is something that is part of the personal representative's duties. And I suppose one can imagine circumstances where it would be obvious that a personal representative had not disposed of a body properly. And so I find it a bit surprising this was something the court felt it couldn't even make a declaration about. But I think if it had made a declaration, it probably would have found that the burial had been proper. Now, in relation to Section 116, as far as the law more generally is concerned, it's interesting the court felt it wasn't a two-stage process where you identify your special circumstance and then ask whether it's necessary or expedient. It's rather a single step of asking whether it's necessary and expedient in light of a special circumstance. I don't think anything turns on that, but for future cases, we can all take note. Now, the court in this case wasn't satisfied it was necessary or expedient to appoint the mother as administrator. Her main reason for doing so, the burial having already taken place, was to pursue an exhumation application, and the court was satisfied that it wasn't necessary for an exhumation application for the mother to be a personal representative. So it wasn't even necessary on the facts of her own case. And in the circumstances, the court wasn't willing to grant the order sought. Now, I think what the point of interest for the case, and as I said, there's an interesting parallel with Buchanan and Milton, is the court gave additional weight, I think it's fair to say, to the order of priority to administration under the non-contentious probate rules. Because, of course, the spouse in this case had priority to a parent, to a grant, and therefore the court was willing to accept the way that she had acted, which it's fair to say was criticised by the mother, on the basis that she was the person that the law had chosen as primarily entitled. But what was missing from that analysis is the fact that the spouse hadn't obtained a grant. She had acted without a grant in disposing of the body. Now, she hadn't needed a grant to substantiate a claim for an injunction, for example, but administrators in general can't act at all without a grant because they don't have any authority to do so. And what the court said here is that the law in England gives the decision to a surviving spouse in priority to any other member of the family, and that where there's a difference of opinion between a widow and other family members as to the way in which a person should be buried, it is the widow, in the absence of other factors, would normally have the final say and is entitled to override the wishes of family members. Now, one can sympathise with that analysis, but it's quite a jump from the non-contentious probate rules to reach this widow has the final say analysis, particularly if the deceased appointed an executor. It would be the executor who made the decision and not anybody else. So I think Gnown's an interesting case, and it gives some support to the idea that administrators might be able to act without a grant in an appropriate case. And an attempt by the mother in this case to criticise the spouse for having acted without a grant and to use that to strengthen her application under section 116 was unsuccessful. But I don't think this principle can be taken too far, because the starting point always has to be, is there an executor? And if there isn't an executor, the starting point ought to be the person entitled to administration needs to apply for a grant. So that brings me to the end of what I wanted to say about the cases in this area. I realise this has been a bit of a whistle-stop tour through the area, and I hope it's been interesting. I see I have got at least one question. Now is your opportunity, if you'd like to ask me anything about these topics, to put your questions in the Q&A box, and I'll do my best to answer them. But I'll have a look at what the first question is. It's asked whether the executor in the Brady case was a lawyer or a family member. I think the questioner thinks it was a lawyer. I think that's right, although I wouldn't swear to it. I think that the executor had possibly been his lawyer at an earlier stage, and that's why he'd been named as executor. But it's fair to say, whether a professional or a layperson, he was failing to do his primary duty, which was properly disposing of the body, really as soon as is reasonably practicable under the circumstances. Somebody has asked whether if there's a letter of wishes, does that take precedence to the widow in an administration case? I think a letter of wishes would be a relevant factor that the court would take into account in deciding who to appoint under section 116. But it won't be decisive because of the Williams and Williams principle that a deceased can't direct the disposal of his or her body. They can only make requests which they hope will be followed through by the administrator. So I suppose if you had a case where the widow wanted one thing and a family member executor wanted another, in that case, I think that the executor would have the final say and would be able to trump the wishes of the widow, and they would be strengthened in that decision if there was a letter of wishes. Another question's arisen is, how would the court decide between two executors equally entitled? Well, I think that, assuming that they had both taken a grant, I think in that case, the court might be prepared to give directions along the sort of trustee direction type application in an appropriate case. Alternatively, the court might be willing, if there hadn't been a grant, to make an order under section 116, selecting one executor to the exclusion of another, which is one of the things that the court can do under section 116. So if there hadn't been a grant, I think it would resolve the situation in the same way, which is to pick between the options based on what their proposed course of action would be. But if there had been a grant, the executors should be making that decision together. And if they can't agree, either one of them needs to step down or they need to get directions from the court. So a further question, have you identified any cases involving disagreements about who should be permitted to attend a funeral service, i.e. in circumstances of family estrangement, turmoil or disharmony? I'm afraid to say I haven't, and I'm not sure how the court would resolve that situation. If it's a private ceremony, I suppose the person organising the private ceremony would have control over who attends. And I guess that decision, as with other decisions relating to funeral steps, would ultimately fall on the lawful personal representative. So I suppose in an appropriate case, the personal representative could make arrangements for a funeral which would de facto exclude somebody from attending, but that would be a step that they would have to take very cautiously, as they may well face criticism for taking that kind of action. I wonder if there are any other questions. Well, as there don't seem to be any, can I say thank you to everybody for attending the talk today. I hope it was interesting. Somebody asked about slides. I'm sure if you contact Chambers and you wanted a copy of the slides, those could be provided. Or indeed, contact me directly. I've got my email address on the last slide there. And with that, I'm going to wish everybody, if I don't see you before Christmas, a very happy Christmas. And hopefully see some of you in the new year.